Hi everyone, this is Mr. Tek Wong. I shall be your lecturer for this module. And my job is to teach you guys all the essential factors and features on succession and probate practice. There will be lots of adjustment for you guys to go through because of all this COVID-19. And I think things may change, hopefully for the better. And if everything goes on all right, then I hope that we can have this face-to-face lecture for the coming lectures that we're going to teach. Now, my name is Tek Wong. I'm a probate lawyer. I've been teaching probate practice for a number of years, and I've been teaching a long time ago in the Polytechnic, training students to become legal executive, and probably this is my 9th year or 10th year in space here, teaching this subject. And then I have been practicing for about 35 years. And basically I do teach also annually on the Law Society CPD on succession. And basically that is for training lawyers annually, giving presentation and discussion on interstate succession as well as testate succession. So in this area, in this subject, probably, sorry about this, probably I think I know the bulk of the data. In case you guys have any problem in your daily practice, sorry about this. In your daily practice, then you run into a problem, then you can always raise it to me. Then hopefully I can discuss with you. This can be done before class, during the intermission, as well as after school. Now, there are various expectations from students. There's a vast division. Some of the students are very ambitious, just like the students that have studied under me, and there are a number of them already become practicing solicitors. And yet there are some of you who are very mediocre, meaning just average or so-so. The only thing that they want to come out here is to finish a diploma and move on. So regardless of your expectation, I'm trying to pull you up to a level which is higher than you begin, hopefully. Some of you will move on, and some of you will stay behind. Apart from the examination, there will be the term assignment. I'll be giving you the or discuss with you on the assignment at the 10th lecture. So I'll go through with you the various questions, and hopefully you'll be able to understand the topic on the assignment a little bit better. As far as the teaching medium is concerned, I'm bound to teach you in English, So in case you want to ask question openly during class, I think you have to speak in English. But then if there are any other problems that you want to discuss with me, like at the break, then by all means you can do it in Chinese. There is one thing that I want to caution you, because I will not give you any tips personally for examination. So don't come to me for this purpose. Otherwise people will be complaining that I'm doing favor for some of you and then prejudicing the others. Apart from this, after you have finished this module, if you have a problem in future, you can go and ask for my email, and then by all means you can have whatever questions that you want to discuss, you can discuss with me. So that will be free of charge. And that's my practice. One of my mission is to make sure that I know what are the problems concerning Okay. Testing. 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 You see, you have to go through this hardship. That's the one of the expectation for being a student, you know. Testing, 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 testing. Okay, those at the back, can you hear me now? Okay, yeah. Testing, testing, testing. Testing. No. Testing. Testing, testing. Okay. Testing, testing. Testing, testing. Testing, testing, testing. Is better now? Right. Okay. Okay, testing, testing, testing. Yeah, okay. Yeah. Just stay for 1 minute. Okay. Now, the other thing is, I know you guys, when you have to come through this class in the evening, it will be very difficult because you have to work in the daytime, and then you have to skip your supper. And by the time when you go back home, we finish at about 10 latest. Usually we get up at 9:30. By the time you go back home, probably will be about 11 something. And some of you will be living far away in the new territories. That means you have to travel for 2 hours and come here and sleep for 3 hours. So it's very difficult. I don't mind whatever things that you bring in here, just to, raise your spirit. So whatever you want to do in order to enhance yourself, you can come, with soft drink, whatever food or whatsoever, as long as you don't make a nuisance, okay? I don't even mind when you come in here to sleep, It's better to sleep here than sleep at home. Thank you. And also the other thing that I like you to sort of treasure yourself as a Hong Kong Space student. Don't ever give yourself any excuse for not coming. Once you started the first time, the chances are you will never come back. So no matter how busy you are, just come back here even at 9 o'clock to see me for 30 minutes. Or for whatever reason you have to leave earlier, no problem. As far as personally I'm concerned, I don't mind you got to leave in the middle of the class, because at least you enjoy the part you stay here. So at least you pick up something from me. It's much better to get what I am going to teach in class than reading the PowerPoint or the handouts or the textbook. Because usually the exam questions will be based on the material that I talk about. So basically, you start off with the PowerPoint, and then in class you know what I say is important, what I say is less important. So you guys don't have to waste your time. So if you are really aiming at a pass, even assuming that you don't do no studies at home, as long as you come in here for 10 lectures and sleep half the time, at least, and you have half of the 10 lectures, then you should be able to get through what I want to talk about. I have tried to make the discussion as easy as possible. So these are the things that I want you to share with me. The best thing is here, I don't remember your names for you guys. Even in the days when we don't have to wear our mask. Even if you come in, I don't know who are you, any Tom, Dick, and Harry. So as long as you're here, I teach. As long as you go, then go and gone. All right. So next time or in future when you see me in court, by all means, then just say hello to me. This is Mr. Ted Wong. Usually I do quite a bit of contentious probate practice. So in case you get involved, then just come in and say hello. I have handled quite a few cases on probate. So if you check on the judiciary on the judgment, and you check out the name of my firm, it's Longsham & Co., or my personal name, I'm known as Mr. Ted Wong. When I represent myself holding out as a solicitor, or sometimes when I act as what we call the independent professional administrator, usually my name is referred to as Wong Tek Shing. So go into the judiciary and you can check out, then you basically will see the kind of cases that I have handled for the past 30 years. It is a very interesting topic, and it is also a very worthy subject as far as spending your time and trying to get into this area to become an expert. I make fairly good income from being a probate lawyer. I remember my first case that I handled in about 89. That was a New Territories Qing law on the Zhou Tao land, which lasts for about 5 to 6 years. It's a fight on managers of Zhou Tao. That was the first case that I really get my first bill income as a solicitor. The first time that I really get a bill for my legal costs exceeding 1 million. Remember, in those days that was very good income. Very good income in those days. And then the other case that I handle in my career is the case of Anita Murphy. The case that I handled since 2004. She died in 2003. I handled the case in 2004. And then all case is a hallmark case for myself. It's very interesting. And then I represented charity, and it was so lucky that we actually won all the way to the end. So that was the second case that I really got myself quite a bit of income for all these legal costs. So that was the first time I get my bill exceeding 4 million legal costs. And since then, I got involved in various contentious cases. Quite a few of them represented the listed company, and then all these fights. In this year, in several years past, I have been handling a case of a listed company father who actually ended his life by committing suicide. He hanged himself. And then there is a fight among the children. It still goes on. That got involved about several years on administration of estate. And then, most recently, I got a case on the making of will. So the will I made was back in 2008. Again, another listed company. I made the will for the mother, and then the two sisters of this listed company fight against each other for so many years. And then when the case come to me last year and beginning this year, the whole thing is on discovery as to the making of will. The will itself is very simple, because one can find it. I tell you all this because all these are information that you can get the judgment online. So there is no confidentiality on this area. Any other sensitive matters I will not tell you because of this confidentiality problem. So I remember I was a solicitor preparing, getting instruction, and then being a witness, attest the will. It is a will that I drafted, only one page. And in terms of the estate of this mother, old lady, in those days it was about 4 billion. It was in 2008, and then she died subsequently. So the estate by then multiplied by 10 times. So Hong Kong is a funny place. The case is still on. I don't know whether I'll be going, I have to, discover more information on my part. So one thing that probably will touch on you guys is on will making. Probably in any of the solicitors' firm, one of the easiest things is to do like prepare a Section 7 PA, prepare a will. Very simple. You take your client in, draft the will based on the precedents, change the names, the ID numbers, and then you explain to the testator. Then when everything apparently is done, then you take it before your boss. The two of you become the witnesses. So this kind of will drafting is very common. It's much of those very basic stuff which is being advertised in local newspapers. So if you buy a copy of Oriental Daily, probably probably you can see the whole pages of advertisement. Over 20 or 30 solicitors. 90% of them will do will drafting, will handle probate application, etc. So will making, sometimes they do it for 2,000. Sometimes when there is a promotion, they charge it for 1,800. For new starters, 1,500. Okay? So it becomes something which is not really worth the paper it is written on. But hopefully after I take you guys through these lectures, course of the lecture, you probably will have a second thought as to whether or not you would like to do it. In several of those popular solicitor firm giving advertisement, if you are being charged with the will drafting, probably you'll be doing about 10 wills a week. Okay, so it becomes a very simple problem. But then, when you guys realize the repercussion, namely the after effect, it is very common that people will criticize you because of your negligence. What kind of negligence is this? We'll discuss it later on. But for this first lecture, I will simply tell you that you will have to be very, very careful. It's easy to miss the thing. The other thing is, as a probate clerk, there's something really very unique here in Hong Kong. In Hong Kong, we have three focus of solicitors firms. City firms, they are focused on this listed company or big deals, M&A, so on and so forth. The other, we have rapidly a fast-growing groups of solicitor firms from across the border, from mainland China. Most of them will be focused around this area in advocacy. And then the last group, which is a traditional group, probably will be the ones that you guys are working. Small, medium-sized Chinese Hong Kong solicitor firms. But the reason why we are able to survive is because of the unique circumstances where we are in. The unique feature is on the rapid increase of the value in landed property. Usually it started with a short story. It will be the generation belonging to your grandpa or grandma. They came from mainland China. They got know nothing. So what they have done is during their lifetime, doing 3 jobs a day, and they managed to buy a cubicle. A very small cubicle in Mong Kok, in Sam Shui Po, or Jordan area. Then of course, time flies and they die. Then that comes to your parents' age. And when it comes to your parents' age, and then they have kids like you guys, the vast difference is you guys are more educated, and the common feature is you guys will be migrating, settling overseas. Canada, USA, Australia, England a little bit. So all this value change, and so is to do with the value of the cubicle. One example that I have personally met and dealt with is, the cubicle was first bought in about the 60s, $200,000. 100,000 odd. Subsequently, recently, got the administration of estate. The same cubicle now rounded up to 7 million. Nowhere in the world when you can have a landed property that can increase for so many fold. And this is something limited to Hong Kong. In PRC, they will have cubicles built. People will buy their own home. But then because of all this control, then the increases in price is being controlled. And what is even worse is properties in North America or down south, down under, in Australia, probably in your whole life, now you're 20, by the time you get to my age, 70, the land price is still the same. So you have been working like a dog, paying heavy taxation, and the increased earnings that you have gained from the house, again, is subject to a lot of heavy duty. That means your asset value doesn't change that much. So that is an irony. And Hong Kong is still the only place. Therefore, we have, now the feature in Hong Kong is, we have got a lot of overseas Chinese. They buy properties in Hong Kong. They invest their funds in Hong Kong, buy listed shares. This is one area. The other area is people from across the border. This is a feature that only surfaced in the last 10 years. PRC people are now much wealthier than us. We guys are just like chauffeurs, shopkeepers now, driver, okay? They got lots of money, they got tons of money. And they got different kinds of overseas passport. Their average salary would be probably 5,000. And then when they are being arrested, even the walls are being all stored with all this currency, renminbi. So they're talking about 30 billion, 40 billion. Any government officials, any merchants in PRC, they are multi-millionaire. And it happens every day. This week arrested one batch, and then next week another group will be arrested. But that is the kind of culture that you have to accept. Okay, we are not going to ask about the source of the money. We are not talking about anti-money laundering. But the fact is, people from across border, they will make sure that the money that they earn are being stored in a place away from the mainland. There are only two places in the world that they will store their wealth. One is Singapore, the other is Hong Kong. Hong Kong is a much better place because of the convenience and because of all the channels for money being funneled into Hong Kong. So therefore, in this past 10 years, on probate, we got a lot of foreign element. In terms of locations of assets, in terms of the next of kin, in terms of the beneficiaries, in terms of the location of the deceased. All this makes things so interesting and so confusing. what I intend to say to the class is, probate is something which is very unique. Very unique. Because apart from the three groups of solicitors that I've just mentioned to you, there is the fourth group of overseas solicitors. And they are the solicitors from the offshore islands, what we call the low tax haven. Bermuda, Cayman, Cook Island, Jersey. We got all kinds of solicitors they got involved. So when there is money being found their way through various vehicles, like offshore company or offshore trust, all this make it a feature that becomes so complicated as to the kind of knowledge that you need to know, and also the court that is going to try the case. Against this background, we have this concept called trust. Trust is a very funny thing. For those involved on administration of estate, you've got all kinds of trust, resulting in the breach of trust and the breach of fiduciary duties, so on and so forth. But then, Hong Kong has been trying to amend the trustee ordinance in order to make the law more flexible to attract more trustee corporation to get Hong Kong as the jurisdiction for formation of trust. Not very successful. Not very successful. Because the rationale was that in 2013, the trustee ordinance was amended, and then the government took the view that we should be a little bit more conservative. So we should be similar to the trust law which is now prevailing in the UK. Instead of moving to the direction on all this low tax regime. So we are outcompeted by, for example, Cayman Island, Jersey. They have banned the trust law, so much so that there are a lot of protection created by the jurisdiction offshore, make it much easier for people to move around, to use trust as a tool which incline to be more in favor to the said law. Well, at this juncture, when I say the tool, you probably will not feel the significance. But then when you realize that recently there is this case filed by the old Madam Law with the other law family against HSBC trustee. The focus of the fight is the professional trustee are not listening to them. So the criticism was that they have betrayed the said law. But that comes into what we call the letter of wishes. And it boils down to what we call a discretionary trust. Discretionary trust, most of the listed company will have a discretionary trust formed in Cayman in order to hold the family shares. No problem? Okay, no problem. But once there's a problem, you have the problem of how and when and who can enforce it. You have to start all this satellite litigation, one in Hong Kong and the other one in BVI and the third one in Cayman. The reason is that the trust is formed in Cayman with the trustee, and then through a company which is formed in BVI, and in turn hold the assets in Hong Kong. So this is a very common feature. So there are these three different jurisdictions. This is one development. And then, on the other hand, across the border, there is another wave of development, which is the trust ordinance in PRC. They have changed it. They have come up with this trust ordinance, the Trust Act. But as you will realize, this kind of trust is what we call a commercial product. It is not a trust in the sense that we understand. It's a trust used for investment. Just last year, there have been a large scale of arrests of these people in control of this trust company because they have a default of all these investment products. Last year is very serious, and then the mainland government is now saying that, okay, we would like to have a control over all this trust business. So this kind of trust business, they use the same name, but it's so difficult, and it's so different. Their trust is not our trust. So there's nothing to trust. Now, with all this background, if you guys are ambitious, and let's say for the next 10 or 20 years, this subject will be the entrance level. Once you know all this in and out, then it will open the door with all this estate planning. It will continue to happen until 1946 and beyond. It's because one can see that the mainland government will still like to use Hong Kong as a place for offshore financial center for PRC. As long as that is still on, then you guys will be able to perform. The unique thing is Hong Kong, if you're really an expert, you don't need to be a lawyer. You don't need to be a barrister. You don't need to be a foreign lawyer. You need only to be a seasoned probate clerk. That you do, as long as you know what you're doing. Because there is nothing that by law that would require a solicitor to handle it. So as long as you get involved, this is something that you can get your expertise. And also the unique feature of this is a kind of a pseudo area. It's considered as a kind of a hybrid. Hybrid in a sense, for will making, there is no law that will must be made by lawyer. Lots of people making wills themselves. People get higher education, they'll go online, and then they'll get the president, change their name, and then make all kind of changes that they like. So that is their will, free of charge. They feel they are in total control. They don't need to spend anything. On the other hand, we have the wills in Hong Kong that you don't need to make an English will. You can make a Chinese will. When we talk about the wills ordinance, you know that a will is something that can be created, that can be made by anyone. Okay? You don't need a lawyer. You don't need to be an LE. Just write something in the middle of the night when your wife or when your husband run away, when your kids have betrayed them or betray you and they got a divorce, or they robbed your money, so you got so frustrated in the middle of the night, then you start to write something. That is your will. We got lots of this informal will, which is recognized as valid. That makes it very interesting. Because if you know the whole thing about testamentary capacity, knowledge and approval, then you know how to deal with the validity or the challenge on the validity. And remember, barrister cannot handle probate, non-contentious. Grant application is a monopoly for solicitor firm in Hong Kong. So if you're a counsel, you cannot do it. You have to do it through the Hong Kong firm, legal firm. Likewise, if you're a foreign lawyer, you cannot handle the local grant application. You have to make it in Hong Kong. So all this will make it such a confusing state. In order to deal with all this kind of stuff, which is a will, and then mixed with all this kind of trust. And then the third thing is one of the unique features in Hong Kong, which is different from PRC, is the ownership of property. In Hong Kong, we know that there is a difference between registered ownership and beneficial ownership. And this is a source of headache. It created all kinds of problems. So therefore, one will have to, test or challenge the beneficial ownership. And then again, in our field, we got other things, other sideline products, which is also challenging. One thing is called donatio mortis causa. Donatio mortis causa is something that you're about to die. Okay, the old lady give a bunch of key to the next door neighbor, thanking the next door neighbor for looking after her in her final days. Okay, please take the keys and that will be yours. There are several cases that the court has held that this is a beneficial DMA, donatio mortis causa. That is to say, a deathbed gift. And then, the other thing is, we have other things called estoppel. Estoppel happens on the other end. It's some kind of constructive estate planning. We have proprietary estoppel, we have equitable estoppel, we have estoppel by convention. All these are very difficult subjects or doctrines to be understood. But it happens around this area so much. You'll be surprised to know that succession and probate practice, if you really get involved into it, it includes on all this kind of estoppel. Case that has led to the court of final appeal is the Willie Hurst case. That is a case concerning equitable estoppel. The fact is very simple. A man can talk to and agree with his girlfriend. Okay, why don't you live with me? Let's be common law husband and wife. Okay? You cohabit with me. You be my girl. When I die, I will make you a queen. Usually, I will give you my house. So this is what we call proprietary estoppel. The man is the owner of the landed property. All right? Willie Hurst's case is a little bit different. The man was not the owner of the property. The property was held and owned by a limited company, and the man only has 30% shareholding. He gave the same warranty to the lady who cohabited with him. When I die, I will give you this house. When I die. So eventually he died, but he did not give him her house. I mean, he did not give her his house. The argument was that, no, this cannot be a valid estoppel because he did not own the property. When the case comes to the Court of Final Appeal, the Court of Final Appeal talked to the counsel on both sides. I want you guys to consider this concept of equitable estoppel and come back next time. So this equitable estoppel is a doctrine which is not argued by the counsel in the beginning, but is something that is created, thought of, raised by the Court of Final Appeal judges. So equitable estoppel was originally something of a contract. It's a contract law. Except for this William Hearst case, then eventually, so the minority shareholder man died, failed to live up, with his promise. The court held in favor of the lady, and the lady got the shareholding on pro rata basis because there is detriment on breach of warranty, breach of promise, breach of representation. I'm telling you guys all this is to fill you in on this unique feature in this course. And there's so many tools available for you to play around. Very difficult. Unless you have sharpened your knife. If you really know what you're doing, sooner or later you become an expert. Trust, we use it as a tool. Hong Kong is probably the best place in the world that are still using this trust ordinance and the creation of trust. We have even bypassed the UK. United Kingdom is the first country that has created the trust law. But in this past 1 or 2 decades or few decades, trust is no longer a popular object in terms of estate planning. A century ago, if you studied the trust law, you will know that it was very popular in those days. Trust in those days was known as a settlement. That's why in 1925 we have the Trustee Act, we have the Settlement Act. All this is changed this settlement in England. But then 5 decades, 6 decades, it is no longer popular in the UK now on trust because they have removed the tax benefit. You put something into the trust that amounts to a transaction. You get it out from the trust, another transaction. Each transaction you pay a high volume of tax, high percentage. So all this use of the trust as a tool has become a very, what we call disincentive because of the high tax. So in the UK, people don't like this trust concept anymore. Hong Kong is perhaps the only place that you can still exercise the traditional fixed trust as well as the modern discretionary trust. So that's why it's so interesting. And you guys, if you finish this module, this diploma, one thing that you can move on, hopefully, I'm not sure how many of you can do it, is you get yourself the legal qualification, if possible. I'm not sure whether you finish all this will enable you to get the qualification as a legal executive or not. You probably have to study 3 years. Even if you do, that will open up the door because LE will have the benefit to have the right of audience in court for this 15-minute or 3-minute summons. is a very important concept, because by going through court at these initial summonses, that moves you in better control on all this estate planning, even if they turn to be contentious. That will enable you to do a lot more in this area. Okay? So that will be sufficient to hopefully arouse you guys. It's much better to do the contentious probate than to do the traditional conveyancing. If you know what your boss is doing, if you're a small or medium solicitor firm in Hong Kong, you know that conveyancing, how much can you charge? 5,000? 10,000? So usually it's a cap fee. And then if this is a case introduced by an estate agent, you know how the market goes. The estate agent get what they get immediately, and you sit there to do the rest of the job at a fee which is so humble. Okay? So why don't you spend more time to get what we call open up your professional horizon? And the other thing which is good for you guys, I think probably in this class, probably 99% of you are Chinese, or at least Chinese speaking. Hong Kong is the only place where you can get, both of the Putonghua and also the local dialect. And then you guys also know English. That will be tools that you should be able to equip yourself, at least for your whole career. This is the only thing that you can outcompete those solicitors coming from across the border. So in order to fight for yourself for survival, so these are the only things that I can give to you. And I can only talk about from my experience. Because if you are able to equip yourself with at least 50% as what Mr. Wong is doing in terms of competence, then you should be able to make a living all right. Okay? So let's move on. This is the first thing that you will find yourself or appear before your eyes when you turn to the judiciary online platform. Now, I will try to take you guys through to the various resources. And one thing I need you to be able to pick up is to able to get all these resources at your fingertip. Once you know how to get the law, how to get the form, how to get the other references, you will become an indispensable helping hand for the entire firm. For this, there is no shortcut. I would like my students, if possible, every time when you come to class, get the notebook and develop the habit of how to get online. So when you get all the resources at your fingertip, then a lot of the problems, once you got tuned in, can be easily solved. Now, the kind of problem as a probate practitioner that I run into, the problem is, I don't know what the form is. I don't know what the law is. I don't know what the probate practice is. And then I don't know what the judgment is. For example, when you have the white book, the prints are so small, you cannot even look at it. But in order to get survive, all of us should be able or must be able to get all these tools readily available. Don't ask your friend, do it yourself. And don't do it at home. Okay? You got no time to waste. Do it here. That is the best way. If you have no money to buy a notebook, at least you have your mobile. One thing that I have developed is to try to get things, oh, not here. My mobile, I try to install the various route so that I can get things at my fingertip. So this will be a tool that I expect all of you to be able to pick up from me. And the other thing is, we have to be as bilingual as possible. So even though we teach in English, but your clients will probably the majority Chinese speaking. Even in court today, there will be more and more Chinese speaking of bilingual judge. If you go to the family court, most of them are Chinese speaking. In one subject, in lecture 6, we will talk about Cat-Void 1, and that is in family court. And the judges are all doing Cantonese. So you will have to be as thorough as possible on the two languages. Now here, this is the open face, and then this is the entrance, all right? This is front entrance, so that will take you into all these resources. These 3 horizontal bars that will bring you into the various resources that you need to know and need to use. Now, these are the various online services that I think would be of use for us, and that will be useful for the rest of your career as a probate lawyer. Okay, that should be able to handle 90% of the non-contentious probate practice. I have listed up here 13 items in order to familiarize you on the various tools available. And we'll go through them now. The first thing is the judiciary. Now, this is the judiciary. By this, you can see the linkage. See this here? This is where you should be able to follow. You don't have to know them now. The only thing is, when you're to and fro from your work, try to pick up the exact address and then cap on it. Then you become part of your tool. It goes like this. I have done my job already, so this is what I will do if I want to get the resources. This is the first page that you have just visited. So this is the area you would like to go in. The more you learn it, the better you become. The reason why I like it so much is this is in bilingual. Sometimes you find it difficult because if you got only the English version, you probably may not be able to understand all the meanings. Not that you are not able to translate them, literally, but then the actual meaning used in the legal context is not always the same as a layman use. So one thing I find it useful is I can always switch around from English to Chinese, and then your client from across the border simplify Chinese. So you can always get it. For example, we will be discussing one thing is Rule 19 of Cap 10A, which is the non-contentious probate rules. You look at the English, you probably will not be able to understand, because Rule 19, I'll show you in a while, they use all this old English terminology. And unless you actually know what you're doing, it's easy that you'll get confused. It is similar to two ordinances. One is what we call the Estate Duty Ordinance, which is Cap 111. It's so difficult because it follows the English wording, the English Financial Act, and changes all the time in the past. So the terminology is just impossible to be understood. The other similar ordinance is the Stamp Duty Ordinance. Against the terminology, you can say this is common law. In fact, it is not common law that matters. It's the fact that they are using all this old traditional English concept. If you call this common law, it's not appropriate. It would be more appropriate if you call them by the old-fashioned usage. The funny thing is, we are in Hong Kong in a very embarrassing situation because in England they don't use the ordinance anymore. They have abolished them already. But then we are still using them. So all this kind of you can say this colonial heritage. But then in order to understand them, this is not the way to look at them as common law, but rather this is some very old-fashioned terminology that we have to live with. So I was able to try to get the meaning one way or another through all these online services. So I try to take you guys through in order to avoid your problem on this. So this is the first thing. The second item, this is HKLII. This is another source which is put together by University of Hong Kong in looking at the law at the judgments from a slightly different angle. So if you are able to take advantage of both, then you will be able to get an easier understanding. All right, this is ordinance, Hong Kong ordinance. Okay, I want to look at the Wales ordinance. I come here, W. I go to the Wales ordinance, Cap 30. So that gives you the Wales ordinance. Okay. I just talk about, let's say, Section 5, signing and witnessing of a will. This is a very popular topic for examination. It comes out every year. How are you going to understand them? All right? This is from HKLII. In order to understand it, you have to read them, but there are more to it. All right? Look at this. Let me ask you. But no form of attestation shall be necessary. What does that mean? It's very difficult to get a full sense of it unless you know the kind of terminology, which is not always easy to get yourself available. The way I do it is, if I don't understand it, I come in here for HKLII, and then go to the English version, and then I switch on to the Chinese version, which is here. Okay? This is here. So, switch on. Then immediately, you know what that is? Okay, this is what it says. Particularly for those of you who is not a probate practitioner, so you want to try to digest the meaning at very short interval, which is very difficult. Okay? So what I would suggest you to do it is, whenever you have problems like this, compare the English and Chinese version. Then at least you can get some sense out of it. And HKLII also have something which is additional. You see there's something in blue. Whenever we see the wordings in blue, it means that it's linked to another useful source. Okay, now I click on here. So it goes back to the definition section. Now, this is particularly useful if you want to get some meaning on the statute. Otherwise, you have to get all kinds of references all across the table. But then with this, once you get accustomed to it, then things will be at your fingertip. All right. You go back to English. And then here. Now, this is the list of database. This is cases. This is legislation we have just seen. This is the cases. Cases is the judgments. This is the judgments. Okay, Hong Kong. Call the first instance. Look at what are the judgments available. You go by the year or by the letters, alphabetical order. So let's see. What are this? This is January 2021. Moves all the way down. Okay, now this is October. See this? This is October. going down. So the last one that they have listed up to is October 29th. So this is how you can get the update judgments. All this is free of charge. So that has the convenience you can always turn to. All right, this is a judgment, for example. In all the judgments, they have something in blue sometimes. When you see something in blue, that means it's available elsewhere for further details. Okay, I want to take a look at the case Ng Shao Chun. All right, this is. Now here it only gives you only a digest. So you can see what are the cases. This case Ng Shao Chun has been referred to in different cases. By this comparison, you will be working something like a counsel. You know how the case developed, how the judgments develop. Then you should be able to get it. Okay, this one. All right. Germany funds, full tax. Then they give you to the judgment. You need to play around with all this frequently, because it's not easy to accustom to all this, traveling back and forth. Sometimes it will be very frustrating, especially when you're in a hurry. So just take it as a game, then probably your fingers will tune in no time. So that was HKLII. This one is the law. Item 3. Now, this is the Hong Kong e-legislation. So this is the formal version. This is the formal version, undigested. So you have to say, okay, I want to get it. How am I going to get it? Try this. Okay, we talk about the Wills Ordinance, which is 30. Then you click search. You see this? This is the Wills Ordinance. So all you need, either you remember the name of the ordinance, or you remember the number of the ordinance. That will do. And the other thing that I want you to be careful and pick up is this. On the right-hand side, you see this? On the right-hand side, that there are various kind of choices. When we were in the Hong Kong LII, that is one way of presenting it, and here is another way. Sometimes it's useful for us is on this either Chinese or English, and I like the bilingual part. Now you guys, with all the respect, you are only a beginner. As a beginner, you need to know what the law says. Okay? It's no use to just memorizing it, because in no time you guys will be getting old like me. Your memory fades. But you should know, whenever there is a problem, you should be able to get the best interpretation. One of the easiest ways is to get the bilingual version. So you pick here, bilingual. So either this is PDF or Word format. So let's say I pick the Wills Ordinance. I pick the bilingual. All right. So we just go in. Section 5, what does it say? All right. Section 5, signing and witnessing of a will. This is signing and witnessing. When you say witnessing, okay, it's something like attestation. Not easy to understand. What does it mean by attest? What does it mean by witness? How are we going to draw the distinction? If you use this parallel bilingual version, you go to section 5. This is section 5. Okay, you look at it. I like to refer to this because every year we have examination question on section 5. No exception. It's a must. They talk about attestation. Look at this. Look at the English version. Each witness, I'm at small d here. Each witness either attests and sign the will or acknowledge his signature. What does that mean? You look at the dictionary, take my words, you'll be surprised. You got all kinds of wrong meaning because of all this layman dictionary. Even on the Oxford Legal Dictionary, it may not be as helpful as you like. So take a look here, compare here. Now, each witness attest and sign. Attest here, attest in Jing, and sign. Then you know what the words or what the term means.
Sorry, sir, would you mind enlarging it? It's
Sorry?
difficult to see. Would you mind enlarging it?
Oh, all
it's
right.
very difficult to see
Can I see? No problem.
and difficult to follow.
This is so far that I can go. I just do it as an illustration, and I want you to establish the habit of trying to get the solution. It will be helpful on some of those difficult statutory provisions. For example, the trustee ordinance or Cap 10, probate and administration ordinance. All these are using old-fashioned English terminology. So in order to understand them, look at the Chinese. It will give you some easy explanation. All right? So this is how you do it. Go back. Now, so if I want to change to 29, I'm here. I search. Now this is trustee ordinance. See this? Okay. So again, you compare them. Another thing, all right, I want to go to, this is the most popular regulation that we need to pick up, which is the non-contentious probate rules, Cap 10A. So I click here at Cap 10A, search. Now here, we are already at Cap 10A. So, non-contentious probate rules. I come here. Now let me show you something. Rule 19 and Rule 21 are the most usual regulations that we refer to, and it comes out every year in examination. is Rule 19. I'll make it bigger for you. Rule 19 is the priority order for grant application where a deceased died with a will. Okay, then you know what that is. Compare the English. Order of priority for grant. My students sometimes get confused on different priority. One is priority for inheritance. The other is priority for grant. They are different. So this is Rule 19. Now, I like to show you this because this is where all this difficult terminology comes in. Look at this. Rule 19. I'll show you why it is so difficult to understand. This is Rule 19. First priority, executor. See it? Second priority, any residuary legatee or devisee holding in trust for any other person. Probably you will not be able to understand the uniqueness of this. And you go on, any residuary legatee or devisee for life. Now, look at the Chinese version. I'll give you a break at 6:30, okay? Look at this. This is what it says. This is for life. I have to make it smaller to enable you to compare. Look at this. Look at number 3. Number 3, the English version says, any residuary legatee or devisee for life. See that? Any residuary legatee or devisee for life. Look at the Chinese. For life, 終身受益. Residuary, 剩餘. Then legatee or devisee, there is no such distinction. See that? So the translation is not a literal translation. It's not a verbatim translation, so to speak. It's not being translated word by word. Now, that brings us to a huge, serious problem. When it comes to application for grant, one of the present requests by the probate registry is we must faithfully follow the words of the specified form. And the words here, as you can see in number 3, small 3, Roman 3, residuary legatee or devisee. But then in Chinese, there's no such word or. It's simply non-existent. The only answer that we can come up with is these are two separate statutory provisions. They don't mean the same thing. If you are you're being asked to follow verbatim, comply with the words in the law, then immediately, if you follow the English version, it's one pattern. If you follow the Chinese version, it's another pattern. But then knowing that in Hong Kong now, you can make a grant application whether in Chinese or in English, that in practice will create a world of difference. Okay, this is only an illustration so that you know where the pitfall will lie. So unless you really get into all this, you don't even know what the problem is. You have to compare the two different translations in order to know what the problem is. So if you want to apply for a grant for use in Hong Kong and across the border, you probably would like to have a grant to be issued in Chinese. And the application form is in Chinese. If that is the case, you use the Chinese wording, which is one set. Then when you want to use a form which is for use in Hong Kong and for receiving overseas, which has to be in English, then you use a different version in English. So that means at all material time, we will have to have a different mindset in order to fit in what are the best ones to be chosen. This is just an illustration to show you the bilingual stuff. Number 3. Number 4, dictionary. Now, one thing that we should be able to follow or to look is the best legal dictionary is this dictionary. This is the best. And this is the most updated. And this is the one used in the Hong Kong context. If possible, follow the translation here and pick and choose. Okay, I type in the keywords, I search. Okay, it shows bona fide or bona fide. You see this term, bona vacantia. Now, all this go by the alphabetical order. Then at least you know what they are. In Rule 21, Cap 10A, the last priority for grant is the government. They are entitled to take all the estate under the doctrine of bona vacantia. What does that mean? Use this vocabulary, use this dictionary, this glossary, then you will know, bona vacantia, 無主財物. And it's easy because you see that this is Cap 73, Section 4. All right. Then immediately it takes you to the right place in order to illustrate what the term means. And this is very useful because in all this, traditional terminology, they like to use all this Latin. It's very difficult for you to remember, and you don't even know what they are. Here, this glossary is an update only published last year. This is the most updated, improved version from the judiciary. So I think it's very useful now. Instead of only on the statute, they come up with this, and they give you the idea of find the difficult words that you don't understand, and then you have the chance to look at both bilingual and the source. So I want you guys to really pick this up, and I go back to it here. not able to go back there now. I'll do it later. Why don't we take a break now? 10 minutes.